the breaking news. So, of course, I became aware of this on Twitter just yesterday. Firearms Policy Coalition, a great group, does a lot of hard fighting for the Second Amendment. I urge you to follow them on Twitter, perhaps subscribe as well. Legal alert, federal judge, that's Judge Benitez, has struck down California's ammunition background check requirement, saying it violates the Second Amendment. And this is the opinion we'll be reading today, about 32 pages long. Start the timer for 20 minutes. For those of you who are non-members of the law of self-defense. So the governor, Newsom, immediately issues a press release saying the same fanatic judge. So this judge is a fanatic. It's not even an appropriate use of the word fanatic, but this fanatic judge who previously compared military-style assault weapons to Swiss Army knives continues to undermine the credibility of his decisions. I don't think so. By the way, that comparison of assault weapons to Swiss Army knives was something the judge was quoting from the state's own brief. The state came up with that comparison, the state of California. Continuing with the governor's statement, like clockwork, Judge Benitez has yet again put his personal politics and fealty for the gun lobby over the Constitution and common sense. Guns with bullets are the #1 killer of children in America. Well, that's a lie. California will fight this extremist, illogical, and incoherent ruling. We'll see how extremist, illogical, incoherent it is, because we're going to read it. As we defend our life-saving measures that are proven to keep our community safe. Actually, after this 4 years ago, this ammo background check went into effect. Homicides, unlawful killings in California are up, not down. So that was the governor's rant. Immediately, after the judge released his decision, the state asked for a temporary injunction so they could appeal to the Ninth Circuit Appellate Court, which is the appellate court over Judge Benitez. And the judge, if we have time, we'll take a look at that. And the judge immediately denied the request for an injunction. You think he knew it was coming? You think he already had this denial written out on his laptop? I bet he did. I bet he did. All right, folks, so let's go ahead and jump right in to this decision. Kim Road. Let's see if I can make this bigger for all of us. There we go. Kim Road and other plaintiffs versus Rob Bonta, Attorney General of the state of California. And this is the ruling, the order issued by Judge Benitez in this case. The California Ammunition Background Check Law. Introduction, Section 1. In 2016, California voters approved a statewide ballot measure known as Proposition 63. Proposition 63 created a background check system for the purchasing of ammunition. The voters approved a system where gun owners would apply for an ammunition purchase permit. The permit would cost $50, and it would be good for 4 years. The permit would be renewable and revocable upon a disqualifying event. Under the Proposition 63 approach, when a gun owner wanted to purchase ammunition, he would submit his ammunition purchase permit to a licensed vendor, and the permit would be checked with the state for current validity. I'm going to skip the footnotes in the interest of time. Continuing now with the decision. However, before Election Day, the state legislature enacted Senate Bill 1235, Senate Bill 1235, prospectively amended aspects of Proposition 63, including the ammunition purchase permit program. Instead of creating a system using an ammunition purchase permit that was valid for 4 years, Senate Bill 1235 requires residents to submit to an automated background check every time they need to buy ammunition. The new requirement went into effect on July 1st, 2019. It is Senate Bill 1235's requirement of a background check for every purchase that is challenged here. Why the legislature eliminated the voter-approved 4-year permit system in favor of an every purchase background check scheme is not apparent. Without prejudging the discarded 4-year permit system envisioned by the voters of California, such a system would clearly be a more reasonable constitutional approach than the current scheme. Today, a person may choose to submit to a full credit check to buy an automobile, but he's not required to pass the same credit check every time he needs to refill his car with gas or recharge his battery at a charging station. And the Constitution does not mention a right to own automobiles or carriages or horses. Similarly, when a person chooses to buy a firearm, he is required to undergo a full background check. However, until now, he was not required to also go through a background check every time he needed to refill his gun with ammunition. And the Bill of Rights commands that the right to keep and bear arms shall not be infringed. With the recently enacted ammunition background check laws, gun owners in California undergo background checks more than 1 million times each year simply to buy ammunition. They are not allowed to buy ammunition from out-of-state vendors and have it delivered to their homes. They are not allowed to buy ammunition in Arizona or Nevada and bring it with them back into California. Though they are citizens entitled to enjoy all of the constitutional rights, Californians are denied the Second Amendment right to buy ammunition for self-defense at least 11% of the time because of problems with the background check system. In earlier proceedings, this court found the background check and anti-importation provisions likely violate both the Second Amendment and the Dormant Commerce Clause and entered a preliminary injunction. That order was appealed. The Court of Appeals remanded the case for further proceedings consistent with New York State Rifle and Pistol Association versus Bruin. After remand and pursuant to federal rules of civil procedure, the court consolidated a hearing on the renewed motion for preliminary injunction with a trial on the merits. That's what this order is about. Subsection 2, the challenged state law provision. Ammunition sales in California must now be conducted by a state-licensed ammunition vendor in a face-to-face transaction. A California resident who seeks to buy firearm ammunition must first pay for and pass an electronic background check each time he or she wishes to make a purchase. The buyer must prove he is a citizen of the United States and a California resident in order to submit to the background check. The background check must report that the buyer is not a prohibited person, or more specifically, that the buyer is an authorized person. In the language of the statute, to buy ammunition, one must be, quote, a person authorized to purchase ammunition pursuant to Section 3370. The ammunition vendor shall verify with the department in a manner prescribed by the department that the person is authorized to purchase ammunition. If the person is not listed as an authorized ammunition purchaser, the vendor shall deny the sale or transfer, close quote. The law provides an exception for ammunition purchased at a commercial target range, but the ammunition must not leave the range. There is also an exception for purchasing ammunition from a spouse, registered domestic partner, or immediate family member. However, without a spouse, partner, or family member to buy from, there is nowhere else in California one may go to buy ammunition for defense of self, defense of family, defense of property, use in a militia, hunting, or recreational shooting. A person who needs to buy ammunition has 4 paths to seek authorization: 2 types of background checks, a certificate of eligibility verification check, and a firearm purchase check. Today, the cost of submitting to a background check varies between $1 for the standard check and $19 for the basic check. The certificate of eligibility verification check requires first obtaining a current certificate of eligibility, which demands one go through a time-consuming and expensive process. The fees for a firearm purchase check and any ammunition at the same time are currently $37.19. Whichever path is taken, the background check cost is the same to buy 1 round or 1,000 rounds. A person in California may not purchase from vendors outside of California unless the ammunition is delivered directly to an in-state California licensed ammunition vendor, whereupon the buyer must then pass the background check in a face-to-face transaction. All of this was described in detail in the earlier order. Section 3, the plaintiff's continuing Article 3 standing. This court previously found that plaintiffs had Article 3 standing at the outset of this case. Defendant, California, continues to challenge the plaintiff's Article 3 standing. Now that all of the evidence has been received, plaintiff standing may be considered again. In other words, that the plaintiff has standing to appear in this federal action. To satisfy Article 3 standing, a plaintiff must show 1, an injury in fact that is concrete and particularized and actual or imminent, not conjectural or hypothetical. They must show 2, a causal connection or causal connection between the injury and the challenged action of the defendant. And they must show 3, that it is likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision. Under this standard, which is the same standard applied previously, plaintiffs have proven that they continue to suffer injuries in fact that are actual and ongoing, that the injuries are directly traceable to the defendant who is the official responsible for enforcement of the ammunition laws, and that the injuries would be redressed by an injunction against enforcement, a remedy this court can provide. Therefore, plaintiffs continue to have Article 3 standing. Section 4, discussion. Plaintiffs claim the ammunition background check laws are invalid for 3 main reasons. First, the ammunition background check scheme violates the Second Amendment to the U.S. Constitution. Second, the anti-importation aspect of the ammunition laws violates the Article 1, Section 8, Clause 3 of the Constitution, known as the Dormant Commerce Clause. Third, the anti-importation provision for individuals is preempted by Federal Statute 18 U.S.C. 926A. This court agrees. Subsection A, the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. U.S. Constitution, Amendment 2. In the earlier order, it was determined that the state background check laws were likely to violate Second Amendment rights because they failed the multi-step intermediate scrutiny test adopted after District of Columbia v. Heller. In Bruin, the Supreme Court rejected the old approach of using different levels of scrutiny, holding instead that, quoting Bruin now, quote, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Close quote. By the way, folks, I've read in live streams all of these or recorded shows, all of these major Second Amendment decisions. In fact, if you're a Law of Self-Defense member, you can go to this shortcut URL. I'll put it up on the screen. lawofselfdefense.com /2A, the number 2 and the letter A. And that'll bring you to this aggregation page where we've gathered up all the Second Amendment shows that I've done. They're a small fraction, of course, of our total number of shows. We focus on self-defense law, use of force law, not Second Amendment, but there's been enough interesting Second Amendment court cases happening that we're starting to build up quite a collection. So if you'd like to see my reading of Bruin or Heller or McDonald, they're all here, lawofselfdefense.com /2A. You do need to be a Law of Self-Defense member to access that, which you can do for just 99 cents, folks. 99 cents. Back now to the decision. Applying Bruin's new lesson, this court's conclusion remains the same. The California ammunition and background check law violate a citizen's right to bear arms. Once it becomes clear that acquiring ammunition is conduct covered by the plain text of the Second Amendment, it should be no surprise to discover that the government is unable to do that which it must now do, demonstrate that California's first of its kind, sweeping statewide restriction on buying firearm ammunition is inconsistent with this nation's historical tradition of firearm regulation. Because these laws are not consistent with the nation's history and tradition, they must yield to the Constitution. All agree that the ammunition necessary to use a gun is covered by the Second Amendment's protection for keeping and bearing arms. The Attorney General correctly concedes that even though the Second Amendment does not reference a right to acquire or purchase arms or mention ammunition, it protects ancillary rights necessary to the realization of the core right to possess a firearm for self-defense. The Attorney General agrees that the core right to possess a firearm for self-defense would include a corresponding right to obtain bullets necessary to use firearms for self-defense. Teixeira, a different decision, makes it perfectly clear, quote, "We recognized in Jackson that although the Second Amendment does not explicitly protect ammunition, without bullets, the right to bear arms would be meaningless," close quote. That Jackson case, also a separate decision, thus held that, quote, "The right to possess firearms for protection implies a corresponding right to obtain the bullets necessary to use them," close quote. This is the historically traditional view. Teixeira pointed out that only 3 years after the 14th Amendment was adopted, the Tennessee Supreme Court cogently observed in 1871, interpreting that state's constitution, that the right to keep arms necessarily involves the right to purchase them, to keep them in a state of efficiency for use, and to purchase and provide ammunition suitable for such arms, and to keep them in repair. After all, and as Jackson observed, a regulation eliminating a person's ability to obtain or use ammunition could thereby make it impossible to use firearms for their core purpose. And Heller did not differentiate between regulations governing ammunition and regulations governing the firearms themselves. Plaintiffs assert that this is enough to shift the burden to the government to demonstrate a history and tradition of ammunition background checks. In contrast, the Attorney General makes 2 arguments to end the case here, at the textual level, before he has to shoulder the burden of demonstrating a history and tradition of constitutional ammunition background checks. First, he retreats and says that purchasing ammunition without a background check is not really covered by the plain text of the Second Amendment or any ancillary right. Second, he says that the background check laws are simply presumptively lawful regulatory measures. Neither argument is persuasive. The first argument employs a rhetorical device to over-describe in detail the asserted constitutional wrong. Having over-described the alleged constitutional right, it is then argued that the detailed description of the asserted right is not covered by the plain text of the Constitution. This is an example. Quote, "Here, plaintiffs wish to purchase ammunition without passing a background check. They also wish to purchase ammunition without having to complete a face-to-face transaction at a licensed firearms dealer, and without the dealer retaining records of the transaction. This conduct is not covered by the plain text of the Second Amendment." Close quote. That was a quote from the California Attorney General arguing in favor of these background check laws. Continuing now with the judge's order. The flaw in this approach is that it focuses on the details of the constitutional wrong and then asserts that these details are not covered by the text of the Constitution. For example, suppose a plaintiff described the wrong like this: "Having been threatened by lawless rioting 2 blocks from home and with more threatened violence anticipated, plaintiff desires to buy ammunition for his firearm today so as to be able to defend himself and his household tonight, but is unable to do so because the background check system erroneously reports that he is not an authorized purchaser." The government would then say that the wrong, as described, is not covered by the plain text of the Second Amendment. But all a plaintiff needs to allege is that by preventing him from buying ammunition, the government's background check system infringed his right to bear arms for self-defense. That is what is done here. For example, the plaintiffs allege that for those who do not have access to a nearby ammunition vendor or FFL, Section 3312 bans and criminalizes the only method by which those affected persons can obtain ammunition for self-defense. The court finds that plaintiffs' allegations of constitutional wrong are covered by the plain text of the Second Amendment. The Attorney General's second argument relies on an old justification, while at the same time avoiding the decision Jackson. He points out that the Supreme Court presumes that conditions and qualifications on the commercial sale of arms are lawful, citing Heller. And Heller quoted, quote, "Nothing in our opinion should be taken to cast doubt on longstanding prohibitions and laws imposing conditions and qualifications on the commercial sale of arms," close quote. The Attorney General then claims that the ammunition background check laws are no more than conditions and qualifications on the commercial buying of ammunition that are presumptively lawful. Heller did not decide that conditions and qualifications on the commercial buying of ammunition, erected and stacked to the extent that would-be lawful purchases are delayed and denied, would be presumptively lawful. Heller did not say that every condition or qualification a government could impose on buying firearms or ammunition is beyond constitutional review. Heller answered a different question, holding that the Second Amendment protects an individual right and that a complete prohibition on possession of a handgun and requiring the inoperability of a gun in the home violates the Second Amendment. When Heller was decided, no state in the nation had ever required a background check for ammunition.